Testing. Okay. Testing. Judge microphone 1. Testing. Judge microphone 2. Testing. Judge microphone 3. Testing. Judge microphone 4. Testing. Judge microphone 5. Testing. Judge microphone 6. And testing. Judge microphone 7. Why? That's why that looks so low.
Yep. Brought my lunch. And I took my client's parents. Talked to
Good afternoon, you can be seated. The matter before the court is Somerset, 25-395, State of Maine versus Douglas Perkins. I see counsel are present. I'm assuming you're ready to proceed. And I would ask that counsel identify yourselves first for the record, saying the name of the party, your name and the party you represent. We are being streamed on the web, both by audio and by video.
Good afternoon, James Mason on behalf of the appellant Douglas Perkins.
Thank you.
Good afternoon, Amanda Seekins on behalf of the state.
Thank you. And Attorney Mason, if you're ready to proceed, we'd be happy to hear your argument today.
Good afternoon, Chief Justice, Associate Justice, Counsel, and may it please the court.
And since you decided this time not to protect any time at all again, let me ask you this. Does the state of Maine versus McLean explicitly was talking about the invocation of the right to counsel and the right to remain silent in the custodial interrogation setting? If, and I know you don't concede this point, but if we were to find that the judge's finding below that this was not custodial, isn't that the end of the issue?
I think if it's not custodial to the extent that our decision only relies on McLean, then I think it is sort of the end of the issue. It doesn't mean that the reasoning behind McLean doesn't apply in this case, and it doesn't apply in non-custodial
Isn't your
settings.
argument that we should extend McLean to even non-custodial interrogation?
It is, because the same underpinning concerns that were expressed in McLean exist in a situation that hasn't passed the sort of nebulous line of going into custody, despite the fact that he was in the middle of a police station in a small room.
I understand that's why I said if, and I understand that you don't agree with that analysis. And if he's in custody, if we were to disagree with the trial court below, then McLean would clearly apply to at least, well, first of all, you wouldn't even have to get to McLean because he wasn't given Miranda. So if he was in custody, game over, right?
Correct.
So.
Correct. But that's why we're asking for both that decision, the custodial decision was, we believe, incorrect, and McLean should be extended because of the rationale still applies.
Well, is that argument appropriately preserved? I mean, what was raised below is that this was a custodial interrogation, no Miranda was given, therefore, statements need to be suppressed. There was no argument of any kind that they should be suppressed, even if it were not custodial.
There was no
And
argument.
that doesn't depend on the existence of McLean, does it?
No, there's no argument that was explicitly made, but it was part of the discussion, and the trial court addressed it. And I think the reason why we have situations.
That it's, if it's non-custodial?
No, the right to counsel issue.
Okay.
I thought we were talking about was the right to counsel. His invocation on 3 separate occasions.
Is whether there is, I guess my concern is if it's, I think in some ways this is being made more complicated than necessary in the sense that if it was a custodial interrogation, everybody agrees there was interrogation. If it was a custodial interrogation, he was undeniably not given Miranda warnings, correct? So there's no argument that the statements would come in if indeed it were a custodial
That's right.
interrogation.
That's right.
So the issue that you're faced with here is that what if it is not custodial, then you're saying they should still not come in for whether even initially or because at least eventually there was at least an ambiguous invocation of the right to counsel.
That's right, as well as the voluntariness issue that we raised.
And I guess my question is, was there any issue raised below that even if the statements were not made in custody, that they ought to have been suppressed? I didn't see that argument was made.
No, and first there's the voluntariness issue, which we clearly say was not raised below. And the counsel issue we are arguing that it was raised sufficiently to be addressed by the court and therefore should have that
But
standard.
it was
But
raised
if
only
not,
in the, and which is also why McLean would apply had he been given Miranda and then had had an ambiguous invocation, but that's not what happened here.
no,
And the court addressed that, I think, only in the context of whether or not it was custodial.
Of course, we can't expect you to anticipate the contents of McLean. At the time that they were making that argument, McLean hadn't
come down yet.
been issued.
That's right.
So if McLean was a new rule and you're relying on that new rule, we have to apply the new rule to cases that are on appeal to us. But McLean, as the chief has said, isn't directly applicable. You're asking for an extension. So you're asking for an extension of, based on the contents of a decision that didn't come out until after the appeal started. So what are the preservation rules for that?
Except I would suggest that that's not the case, but anyway.
Well, I find that I often ask for things that before this court that have not fully come out yet. That's sort of part and parcel of what I do. But you have what McLean said is it explored the fundamental reasons of why we are concerned about what people say when they're being questioned by law
Well,
enforcement.
here's the starting point about when somebody in a non-custodial interrogation makes an ambiguous reference to a right to counsel. What if the right to counsel hasn't attached yet?
I think the invocation of counsel is the thing that we are concerned about.
Why?
Why?
If it doesn't attach yet.
And I don't, just to amplify that a little bit, I mean, you agree that the right to counsel under the Sixth Amendment and under Article 1, Section 6 don't attach until there are actual criminal proceedings. And the right to counsel that was recognized in Miranda had more to do with protecting the right to be free from self-incrimination under the federal Fifth Amendment
Right.
and under a different provision of ours, right?
Yes.
So the question that I think Justice Connors is getting at is, are either of those things even present if it's a non-custodial interrogation?
If, assuming that the right to counsel has not attached at the time that the person is making the reference to a right to counsel.
And I think there is a distinction between when the right to counsel versus the invocation of counsel, because it is an expression of rights. It's expression of, I'm not going to talk to you. And if I keep saying I'm not going to talk to you and you continue to get questioning, then you are dealing with, you will look at the police conduct of when they continue to question after that. And the right to counsel is the same. You have this protection from being able to use, the state being able to use your words against you. And so this broad
Well,
right.
if they don't have the duty to warn you yet either, because the whole point of the duty to warn, whether we're looking at the federal Miranda rule or we're looking at our rules under McLean, it's to offset the coercive circumstances of a custodial interrogation. Now, are you saying that if we assume this wasn't custody, and if we assume it's not involuntary, do we then say, but why would you then need to offset any coercive circumstances?
I think if you are being interrogated, whether it's in a custodial setting or not, and you express your rights, your right to have an attorney, you always have a right to have an attorney. You may not have the right to have somebody be provided for you, but you have the right. You have the right to remain silent. And that right is whether you are going to be arrested
Well,
or
is
not.
that the right that's being protected in the custodial setting or the right to counsel? So the right to counsel under the Sixth Amendment or for appointment of counsel, we can agree doesn't attach until there are actually criminal proceedings, right?
Yeah, that's correct.
So that hasn't attached in this setting, either custodial or non-custodial.
but the right to be free of self-incrimination.
It's
Okay,
it's
that's the
code.
issue.
It's basically code. It's not about the right to have counsel at that moment. It's about saying I don't want to say anything else.
That's right. And the analysis has always looked at these two rights as sort of, they're going together because they fall under this self-incrimination.
And that's why I was articulating that there are two different counsel rights, and one is really, I think, more under Miranda was sort of protective of the right to be free from self-incrimination. And that's
Right.
what you're talking about here.
Yes.
But it's not really turning on the right of an invocation to counsel. You're really saying, is it? Or, I mean, how do you, are you saying that was an invocation of the right to remain silent?
I think the fact that these two rights sort of go together and that they're sort of understood as going together means invoking one is essentially invoking the other.
Are you saying that if someone makes an invocation of their right to counsel, whether or not the right to counsel has attached or not yet, and they just keep questioning you and they just ignore you, does that make the interrogation involuntary?
I think the fact that questioning continues to happen is one of the factors that has been looked at that makes things involuntary.
In the custodial section.
I agree in the custodial setting, but it does not mean that the circumstances have essentially changed. You have somebody who's been brought into a police station. They're being brought into, and I'm making these points
Now, he-
not in the
he-
custodial argument,
Brought himself to the police station.
at the request of law enforcement.
Understood, but that is.
So he's in a police station and he's been there for over an hour. He is in a windowless room. There's a detective between him and the door, and he has made utterances that make it clear he knows he is the only suspect in these charges. He knows the allegations. There was a protection from abuse hearing that had already happened. So
It's sort of bleeding over, though, isn't it, to voluntariness? Is that where you're ultimately going?
because these all do sort of, the same sort of factors are often found in each of them. So if I feel like I'm going into also into an involuntariness argument, I am, because I'm arguing for them all.
Well, and you
But-
can have an involuntary confession without being in custody. The police can just, whip the confession out of you before you anything, right?
Correct. Police can also do things that are, they can do duplicitous things that could lead to a confession.
So are you saying this is a big factor we should look at in the totality of circumstances to determine voluntariness at the point where he says, I think I might need a lawyer? That should be a significant factor in determining under our totality weight that they should have stopped?
Yeah, it's an invocation of a right that's involved with self-incrimination.
Well, let me ask you about that, though. Going to the language, I mean, you're arguing this under the state constitution, right? I mean,
Yes.
you would agree that the federal courts have not recognized that this would, in a non-custodial
That's right.
setting. The Maine Constitution, Article 1, Section 6 says, in all criminal prosecutions, the accused has certain rights. Doesn't that really tell us that where there's no criminal prosecution, there's no institution of any proceedings here, and if he's not in custody, that these rights maybe have not attached?
But this court has weighed into situations that are before that has happened. But the court has expressed concerns about the overreach of law enforcement and the investigations of which they are conducting, and people giving up their right to self-incrimination.
Well, then I'm going to take advantage of the prerogative of a chief. So then that leads me to the question of what is the purpose of an exclusionary rule? And even if there were, you could invoke some of these rights in a non-custodial setting. If it's not involuntary and it's not custodial, why would we have an exclusionary rule?
I assume you asked the question, I was getting direction. You have the exclusionary rule in the circumstances
I mean,
because,
isn't it a deterrent effect? And if there's not, any of these things?
I'm going to say something.
You're going to, but let
We're
him
talking
answer that
about a
first.
confession. An involuntary confession we've always recognized.
I said
an
if it's not
exclusionary rule.
involuntary. I was assuming it's not custodial or involuntary.
so I think the fact that every time what you're concerned about is you have law enforcement making pressure on people to give up their right to remain silent to where they can't, I don't want to say they can't resist, but those are the concerns that this court has talked about, most recently in McLean. And it does not matter whether it is because there's a criminal proceeding that has happened. The concern about what people will do in facing law enforcement and the weight of the government, that concern still exists.
Nope, nope. No.
Okay,
Thank you.
thank you.
May it please the court. Good morning, Chief Justice Stanfill and members of the law court. This court should deny this appeal because the trial court appropriately used its discretion in deciding a discovery sanction to impose. It made no error in allowing the admission of
The
Perkins.
discovery sanction was really no sanction at all, was it? I mean, there's no reason why that statement, an inconsistent statement, couldn't have been used by the defendant in any event. I mean, as a practical matter, there was no sanction imposed.
I understand and I agree that it could have been used as impeachment evidence. I think my reading of the discovery sanction that Justice Mullen included was that the defense could play that regardless of whether it came in as impeachment or any other subsequent rule, that blanketly they were given the permission to play that as part of their case in chief, regardless
So
of.
as substantive evidence as
Yes.
opposed.
Yes. And regardless if the other interview had come in, regardless of how the named victim testified, as a blanket prior to the start of trial, regardless of anything that came up in the state's case in chief, the defense was allowed to play that as substantive evidence in their case in chief. That's the sanction that I read Justice Mullen imposing.
What about the argument that that is at least once somebody ambiguously or otherwise invokes the right to counsel, and that's really a proxy for invoking the right to remain silent, even in a non-custodial setting, that needs to be respected?
I disagree with the position that Attorney Mason has taken respectfully. I do not think McLean should be extended to non-custodial interrogations. And the purpose for that is that the reasoning Your Honor used in writing the McLean decision was directly focused on the coercive environment that custodial interrogations bring about. That's the entire point of it. We want to protect those individuals that are subject to custodial interrogations. We want them to be aware of their rights. That's the whole reason that Miranda's read. That's the sociological analysis that Your Honor took in writing the McLean decision. That does not extend to non-custodial interrogations.
But there's sort of a gradient there. Even if a particular incident or interrogation doesn't cross the line into custodial, it could be just shy of that line because it doesn't qualify under one of the factors, but it still presents the same concern, doesn't it?
I think there are a number of concerns raised, and I think those should be taken into account when considering the totality of the circumstance, both for the in-custody analysis and then also for the voluntariness analysis. But quite frankly, as the case law stands, even if somebody does not ambiguously, if they unequivocally invoke their right to remain silent or their right to have an attorney in a non-custodial setting, that interview is not required to end. This is what we see in State v. Lavoie, where you have an individual who's essentially walking down the street, law enforcement pulls up next to them and says, "Hey, are you so-and-so?" The individual says yes and continues walking. They say, "Will you come back to the police department with us?" He says no. They say, "Will you get into the police car with us?" He says no. They continue, and he continues walking down the road with an officer walking beside him and another one following in the car. This court determined that those two statements, refusing to come to the police department and refusing to get in the car, were essentially equivalent to him invoking his right to remain silent. However, when he was arrested and read Miranda, the initial trial court, as I understand, or the motion court, precluded his interview from being admitted because they said he invoked his right to remain silent. Officers should have left him alone, stopped questioning him at that point in time. This court reversed that decision and upheld that they did not have to exclude his subsequent confession after Miranda, because just because he invoked his right to remain silent during a non-custodial interview with law enforcement, it didn't require that interview to end.
Under federal law.
Under federal law, and that was a state case, State v.
It was a
Lavoie.
state case decided under federal law.
Yes.
Now we're talking about the Maine Constitution, and you're arguing that we should similarly interpret it.
Yes, I think under the Maine Constitution, it's clear, especially in the reasoning in McLean, that we want to protect those coercive custodial interrogation environments, not necessarily the environments, but the right that a person has in those environments. I do think we should not extend McLean and leave the precedent
Well, let's
as it
talk
stands.
about the voluntariness issue. Do you agree that if, whether you're in custody or not, but there's someone being interrogated, and the police say, and the person starts talking, and the policeman says, this will just be between us, okay? It's confidential. Lies. Do you think that would have a problem with whatever he says after that being deemed admissible?
I think depending on the surrounding circumstance, it absolutely could. I don't know that it's the single factor that tips the scale, but depending on what the entirety of the interrogation.
Well, we've kind of said in the past that promises of leniency and things that are not true, like we'll keep it confidential, can alone make it involuntary, correct?
Absolutely, yes.
So if the policeman says something about the law that is being discussed, and they misrepresent the content of that law, do you think that could be a problem for voluntariness?
I think it's a factor that should be weighed in voluntariness.
So here, the policeman said, at 14, you can consent to sex. Do you think that was a problem in trying to convince him that it was okay to confess to whatever it is he did?
I want to clarify, I don't think it's a lie as opposed to the previous analysis or the hypothesis that Your Honor gave. I think there is situations where a 14-year-old can consent to sex. Now, can that 14-year-old consent to sexual intercourse with a person who has an age gap of more than 3 to 5 years? No, of course not. But the statement alone that a 14-year-old can consent to
So
having
he's talking to
sex.
Perkins, and he's saying, 14-year-olds can consent to have sex. They can consent. 13, you can't. And then Perkins says he thought the age of consent was 16, and then he says, no, at 14, you can consent. And you're saying that was okay because in some circumstances, not with Perkins, but with other people, it might be okay.
I think it was appropriately weighed as part of the misviewed factors. Justice Mullen appropriately considered it as perhaps trickery. I just wanted to make it clear that I don't view it as a lie. It's not an entire misstatement of the law. Additionally, couched in that entirety of the conversation with Perkins, they're also talking about the difference of consensual sex and non-consensual sex. And the detective makes clear notes that she wants to know whether we're dealing with a situation that involves consensual sex with the named victim or whether we're dealing with a situation of non-consensual sex.
But
not that
implicit in the statement that a 14-year-old can consent is, you know, if you tell me this was consensual with this 14-year-old, you're not going to get in trouble. Isn't that sort of implicit in what the detective was saying in that instance?
I think that's one reading of it. I also think there could be other
And does
readings.
that fall within the parameters of what we've said is permissible deception when a police officer is trying to perhaps elicit a confession from a suspect?
I think it does fall in the parameters. It is, to be clear, I'm not arguing that it's not some sort of police trickery. I just don't think it's the officer lying to the defendant, which I think would put it in a different
The half-truth
category.
is what you're saying.
Correct. If it was a lie, then it would be a clear, different distinction. I do think it's use of police trickery, but it also was appropriately considered in the misviewed factors. It was raised to Justice Mullen. He put it as one of the misviewed factors. He put it, I think, in his decision. He states that made several misleading statements about the law and about the experience that she had against the defendant. And he cites it other places, I think, in his decision. It was appropriate for him to consider it. It was a statement that involved some sort of police trickery. It was not an outright lie, but it was, I believe, said to elicit some kind of confession from the defendant. Perhaps it was successful because he did confess, whether that was the reason he did or
I take
not.
it from what you said, first, that you would agree that a statement could be involuntary even if not custodial.
Yes, of course.
And do you agree that if a statement is involuntary, are you saying even if it's not custodial, it would need to be excluded,
If a statement is involuntary, then yes, it would be excluded.
regardless of whether it's custodial or not.
I believe so. It's involuntary.
And so then does your argument turn on the two sort of pillars of that it was voluntary and that it was non-custodial?
Yes.
Court below make a finding as to voluntariness?
No, because that issue is not preserved.
Okay, so what do we do with that? In other words, if somebody makes a motion on a certain ground and doesn't raise other grounds, are those other grounds deemed preserved? Or are they, is it an, well, I'm going to put it another way. Are they waived or is it obvious error review? In other words, we do obvious error review when somebody just sort of fails to raise something. But when it's the defendant's own motion and they choose to proceed on certain grounds and not others, is that waiver or is that an obvious error review?
It's an obvious error review. And the reason for that is the purpose behind obvious error is looking at what issues were raised or given any sufficient notice to the lower court to decide and the subsequent party to litigate. Oftentimes we see these motions to suppress, and if it's a blanket motion, perhaps it doesn't give the parties an explicit understanding about what's to be litigated.
So if somebody brings a motion to suppress statements, let's just say it's a motion to suppress statements, and then on appeal, they say, oh, by the way, physical evidence, the search was no good. There was no reasonable articulable suspicion. There was no probable cause, and so the physical search was no good, and that should also be thrown out. Is that, would we say that's waived, or would we review that for obvious error when it was, if it was never raised in the motion below and not addressed?
I believe you would review it for obvious error. And the point of that is that there's no way for the record to be
Why
appropriately.
wouldn't it be waived
Why
then?
wouldn't it be waiver, which would be helpful for you, but.
It would be waiver.
So at what point, how do we discern, I guess, is my question. Is voluntariness something that can be waived if there's a motion to suppress a statement?
I think it can be waived. It depends on what is put in the motion. Here, there's nothing in it regarding voluntariness. There's just blanketly nothing in it for the court to consider or the other party to litigate. It was not raised, it was waived.
It is, I'm looking at State versus Hunt, and it says, we explain that when the interrogation is taped and the facts are undisputed, whether the interrogated person's statements were voluntary is essentially reviewed de novo on appeal. So it's not like we would have to be weighing any findings from the trial court, correct?
I think under that reading, I would agree with you. I'm not familiar fully with State v. Hunt at this moment. I'm happy to look into it more, but I think from what you read, I would agree.
Can I ask about, if we're just focusing on the argument that the questioning should have ceased because Mr. Perkins invoked his right to counsel. I know you don't agree with that, but I guess I'm wondering about what he said in those last 15 or 20 minutes of the interview after the invocation that Attorney Mason is citing to. In your view, was there any prejudice from those last 50? Was there anything he said that really made a difference in trial, or had most of the admissions that were sort of problematic for the defendant been made before that claimed invocation?
The majority of the admissions had been made before the invocation. Like you said, it was approximately 45 minutes or so into the interview. So he had already made admissions and confessions at that point in time to having sexual intercourse with the minor before making any of the ambiguous invocations.
So is there any argument that, even if there were an invocation, that there's no prejudice? Essentially, we don't need to address that issue because there could be no prejudice from these last 15 minutes?
Correct. I would assume if the court had extended McLean or had cut it off after those invocations, the portion of the audio that was played to the jury the first 45 minutes would include admissions in and of itself. There would be no prejudice.
There was a statement about having gone to Walmart with one of the victims. Was that discussed in the first part, or did that only come in at the last part of the interview, and how significant is that?
I don't believe it was discussed in the first part. I would have to look at the transcript to confirm, but I likewise don't think it was significant because he had already made the statements stating that he had essentially engaged in sexual intercourse with this minor beforehand.
One of those statements that came in after is if there's some hard proof that is somehow able to prove that what I did, they're saying I did, then I guess I'm guilty.
That's correct. To be clear, he made additional statements after that invocation. I'm just saying he also made admissions before the invocation.
And those statements about, gee, I guess I'm guilty, kind of stemmed from the inference from the police that they were going to get some DNA, which was also a little deceptive.
It was. If there are no other questions, we'll rest
There
on.
don't appear to be.
Thank you, Your Honor.
Can you address, Mr. Mason, whether any statements made after his alleged invocation of the right to counsel, even if we were to extend this, in other words, to the non-custodial setting, as we've said, if it's custodial, it doesn't matter, the whole thing's out. But if it's non-custodial, what I think I hear you saying is that you're hinging it really on the invocation of counsel, which is also an invocation of the right to remain silent, effectively.
That's right.
And can't we apply a harmless error standard to that? In other words, he'd really basically already confessed anyway.
He had made incriminating statements. That's certainly clear. But I think the Walmart point's very valid because what the state said is
And was that after the invocation?
was after. I don't believe there was anything. I knew certainly after. I don't believe there was anything before. But how the state used that was saying, yes, we have her saying this, and we have the other victim saying this, and his own words help back that up because he puts himself in the
I don't think there's any question that when somebody admits they were there, kind of thing,
Yeah.
even if they don't admit the crime, that can still be somewhat.
And I don't see how you can separate that out because it's not they used his words to sort of pull that together to say look, it's not just her saying this. He's also said it. And so I think there's just no way you can find that it isn't harmless if you do find that. But a confession is voluntary when it is made under the circumstances that offend one of the fundamental values of social policy and constitutional law. That's State v. Hunt. Because we are concerned about the overarching effect of law enforcement using clearly duplicitous methods. The detective intentionally did not read Miranda, made misstatements of law that I don't see how can it be interpreted anything other than consent would be 14. It's fine. If I may just finish. And talking about fabricated evidence, these are the fundamental concerns we have when law enforcement is interacting with the public, and that does not change whether it is custodial or not. That's the concerns we have. Thank you.
Thank you. Thank you, counsel. As is our usual practice, we'll be taking the matter under advisement, issue a written decision in due course. And with that, we'll be in recess on this matter.
All rise.
The matter before the court now is Tammy Lasko versus Almighty Waste, Androscoggin 25-426. Again, I see counsel are present, although actually I can't see Attorney Edwards, but I know he's over there. And I assume ready to proceed. We are being streamed on the web both by audio and by video. I would ask counsel before we do the argument to please introduce yourselves by saying your names for the record together with the party you represent.
Attorney Jeff Edwards, Pretty Flaherty, for the appellant, Almighty Waste of Auburn, Maine.
My name is Peter Clifford, and I represent Tammy Lasko, the appellee. Thank you.
Thank you. And Attorney Edwards, we are happy to hear your argument here this afternoon.
Thank you, Your Honor. Good afternoon, and may it please the court. In a case in which the appellee, Tammy Lasko, was awarded $367,892.89 in damages for injuries received in a low-speed, low-impact, fender-bender motor vehicle
I
accident.
suspect that's really the reason you're here, is that you think the damages are excessive, but that's not the issue on appeal.
Well, it's an issue to the extent that the trial court committed reversible error in excluding the appellant's surveillance evidence
Well, let me
that
ask
would
you
have
about that.
demonstrated the true amount of the damages.
Let me ask you about that. So in this case, as far as I can see, there was a scheduling order issued in May of 2023, which I presume was the standard scheduling order, which would require that witnesses be identified after the close of the discovery deadline in 8 months, right?
That probably was on the record, Your Honor. It's
Okay.
a standard.
It was then extended. The discovery deadline was extended on June 18th of 24. It was extended to October 1st of 24. Right? I mean, and I understand that you didn't have the surveillance done until October or November of 24.
That's when that occurred, after the discovery deadline, actually on the eve of trial. We were on a trial list with Justice Archer, potentially exposed to trial in December of 2024, but the case got moved off that list.
Correct. So on the standard scheduling order, though, requires each party to serve on all other parties a list of the name and place and residence and business address of each witness expected to be called to trial and the list of exhibits not later than 15 days after the discovery deadline. Now, I understand there was a later or final deadline, if you will, but why, even if you don't have to supplement your discovery answers, and even if this information did not occur until well after the deposition of the plaintiff, both of which issues were argued, why would you not have to have indicated the existence of this witness essentially immediately once you had it, because the discovery deadline had already run? And so you did have that information for some months before putting it in the witness list in March of 2025.
And I don't know that the letter and the spirit of that scheduling order was followed by either side of the case. I mean, both parties submitted revised witness lists well into 2025, well after that scheduling order deadline.
Was there any other witness that was a new witness material to anything?
Well, there were new witnesses added by the plaintiff in their revised witness list as well. I understand the requirement to comply with scheduling orders, but I would just point out that neither side did so.
Understand that
when I
you're
submitted
saying
my,
that it's maybe honored more in the breach, but the point is if it's a discretionary call by the court, why isn't it appropriate?
but that wasn't the basis for the court's excluding Corey Dyke as a witness for the defendant. She just excluded Corey Dyke as a witness for the defendant based upon an alleged discovery delinquency, which did not occur.
Okay.
And that's the basis for this appeal, is that the surveillance evidence was improperly and in error excluded at trial based upon the court's erroneous determination that there had been a discovery delinquency.
Well, okay, go to that then. Under Rule 26E, Why isn't this information, though not known at the time the discovery answers were given, that came to your attention thereafter, why isn't there then a duty to seasonably amend the response?
Well, first of all, you got to start at the beginning, Your Honor. First of all, if you review the discovery request served by the plaintiff, and they're identified in plaintiff's motion in limine at pages 38 and 39 of the appendix. Clearly, there was no request for so-called surveillance information by the plaintiff. There was an interrogatory number 13 in which it was requested to identify people who had investigated on behalf of the defendant, but that particular interrogatory, which is the only one that comes even close to addressing potential surveillance information evidence, was objected to on the basis of the work product privilege and not subsequently litigated by plaintiff in a discovery conference or in a Rule 26G conference with the trial court. And I would take the position that surveillance evidence of the type that was going to be offered with and through Corey Dyke was never the subject of written discovery by the plaintiff. I mean, obviously the plaintiff in its motion in limine tried to make the argument that they had made these discovery requests and there had been non-compliance. But again, a fair reading of the requests, which are again are at pages 38 and 39 of the appendix, the plaintiff did not request this discovery. To the second point, again, to the extent that there was a request for
Well, when you intend to offer it, don't you waive your work product?
well, we did. I didn't.
And if
I
at the
identified.
time that you're waiving your work product, how could you stand by your work product objection?
That objection was made, Your Honor, back in 23 or 24.
But if you say, oh, now I'm going to waive it,
Well, I did
you
waive
don't
it, Your
think you
Honor.
have a duty?
On March 14th, 2025, I identified Corey's.
Well, you identified the name, but you didn't identify.
Pardon?
You identified him by name, but didn't identify what the subject of.
I identified by Corey Dyke, and obviously the plaintiff got wind of it because the plaintiff filed a motion in limine to exclude all surveillance evidence on April 7th, 2025. So we certainly disclosed the fact that we were intending to call an investigative witness who was going to testify in regard to surveillance activities or surveillance of the activities of the plaintiff.
Counsel, how much does this even matter? I understand you've made the argument that, you know, picture's worth 1,000 words. It's sort of the video and testimony might show in detail what the plaintiff was capable of, but it looks to me like the trial court credited some of the testimony. I think that you elicited on cross-examination that Ms. Lasko could weed whack and mow her lawn. The court credited all of that and still found that she, although she could do those things, she then suffered for it because of, you know, the post-concussive symptoms she was having. So how much did the exclusion of this evidence really matter in the end?
It mattered substantially, Your Honor. It was dramatic testimony. That was on October 19th, 2024. There were 6 hours of the plaintiff, Tammy Lasko, doing lawn work, including the operation of an electric lawnmower, a weed whacker, rakes, and everything else. And it was all on video. It was quite dramatic, and it clearly demonstrated that she had no disability or incapacity, at least on October 19th, 2024.
But again, the trial court, I think, credited that she was capable of doing those things. It just caused her, you know, to have problems afterwards, her symptoms to flare up afterwards.
And there was more to it than that also. I mean, the fact of the matter, she claimed that she couldn't drive a car and she couldn't work. Well, the surveillance revealed that she was doing an extensive amount of driving 50 miles a day to Wales, Maine to take care of an elderly
Was she
gentleman.
asked about that during trial?
Pardon?
Was she asked about that during trial in your cross?
I don't believe that was addressed. That was, again, it was part of the surveillance package that was, again, only went into evidence, didn't go in evidence, just was an offer of proof to the court at the.
But you had the opportunity to cross-examine her about her activities that you had seen depicted upon this video, correct?
I was able to cross-examine her, Your Honor, but it was not as dramatic as the video, the photographs, again, from 11:30 on October 19th, 2024 till 4:30 on October 19th, 2024. She was engaged in strenuous activities, pushing an electric lawnmower up a hill. All of that was caught on
But,
video.
but counsel,
showing
I
that
guess the concern is that, my concern is this. Yes, the court had excluded the testimony of Mr. Dyke in the videos. Had the plaintiff, in response to cross-examination, testified in a way that was completely at odds with that information, don't you think you could have put it in for at least impeachment purposes at that point? I mean, we do that in criminal cases all the time, where we prohibit, the state from using statements or other evidence. But, you hold the defendant's feet to the fire, but you don't get to blatantly lie when we all know it was something else.
Again, again, we're talking about not just, did you use a lawnmower or did you not use a lawnmower? I wasn't impeaching that testimony. I mean, I'm impeaching the entire medical picture here in which it's claimed that the plaintiff was disabled, incapacitated, had substantially reduced her levels of activities and things that she could do on account of her physical injuries, couldn't drive a car, was basically housebound. I mean, I think that the surveillance testimony would, in addition to impeachment, but just show what her capacity was, her work capacity and her ability to live a normal life.
But if the court had these facts before it, you're asking us to make a value judgment on appeal that the fact that the court knew these things but hadn't seen the video of it was such a different impact that it rises to the point of some sort of error?
Well,
I mean,
the error is in the exclusion of the
right,
evidence.
right, but excluding, so the court, but I'm looking, I guess it drifts into the issue of prejudice. I mean, if the court knew she did A, B, and C from the testimony, and you have a video showing A, B, and C, do you want us to make a judgment call that because you couldn't get the video in, that you were somehow precluded from getting those facts before the court?
Well, again, I think it definitely was prejudicial, if that's what you're driving at. I mean, clearly, look at the trial court's footnote number 7 on page 18 of the appendix. The defense suggestion that MS Lasko was a malingerer is unsupported and offensive. So, I mean, obviously, based upon the evidence that was presented, the trial court rejected the defense's contentions and also chastised defense for even making the argument.
The court heard the plaintiff, the court heard the facts surrounding that, and after listening to all these things, including what I'm sure was a magnificent cross-examination, still felt that she was not a malingerer. Would the video have changed that?
Yes, it would have, because
How and why? Because you see
well,
it,
again,
pictures were-
nobody's seen the video. It's never been presented to the trial court. Obviously, I'm not going to present it here today, but it's dramatic in the sense that it's 6 hours of video. And by the way, not done through any trespass or otherwise from public locations. And it's very dramatic in terms of her activities over an extended 6-hour period on October 19th, 2024. And again, pictures speak 1,000 words, I suppose, is the phrase. But for her to say, yes, I mowed the lawn, or yes, I used a weed whacker, versus actually showing it and demonstrating that she's a person with no physical limitations or physical incapacity, that she can work and live a normal life, that she can go back to skydiving and motorcycling if she so chooses. I mean, I think that's what the video showed, in addition to which it would be not just the video, but the testimony of the witness who saw it firsthand, Corey Dyke. So,
Counsel, in the seconds that you have left, can I turn to the other issue, which is the deposition of Dr. Sweet? And let me ask you one question about that.
yes, Your Honor.
Can you identify any area of inquiry of Dr. Sweet that wasn't covered in the deposition and that would not be harmless? I don't see anything identified in the brief.
Yeah,
That's
that's
why
the
I'm
point, though. It's an 169-page deposition, a discovery deposition. That's not courtroom testimony.
And discovery deposition presumably conducted by you or your.
Discovery deposition conducted by me to basically find out what Dr. Sweet had to say by way of opinions and basis for opinions, but it's not necessarily the way I would cross-examine him.
I understand.
Much like
My question
plaintiff's
is,
counsel had
can you identify something specific, any particular area of inquiry or information that wasn't covered that would have been covered to your prejudice had it been live?
Yeah, I don't know that prejudice is an issue, Your Honor, only from the standpoint that Rule 32, basically, I read Rule 32 as saying that testimony is in person and live, and the exception is the use of depositions, and no exception was applicable here. And again, in terms of presenting it live and in front of the trial court, I think that's what I had the right to do. And I would not necessarily have asked the same questions at trial that I would at deposition, where you lead with your chin. Thank you, Your Honor.
May I have leave for one question? In the rule that permits use of depositions at trial, do we see the words discovery deposition or trial deposition anywhere there? Well, obviously, we don't, and your answer is no. And
It's not covered in the rule, but obviously the practice is, particularly among expert witnesses, you have a discovery deposition, and then later on, if the person's not available, you do a trial deposition.
But we're governed by the rule, not the
We're governed by-
practice.
Absolutely governed by the rule. And it doesn't, you're right, Your Honor, it doesn't make a distinction, but the point of the matter is, I think Rule 32 makes it pretty clear that the use of a discovery deposition at trial in lieu of testimony when the witness is available, which this witness was, is the exception. Thank you.
And Attorney Clifford.
Court. My name is Peter Clifford, and I represent Tammy Lasko. Just wanted to address a few points that I think the court has already touched on. I think the first thing is just the broad latitude that the court has. The starting point for me, and I think for the court, is a well-written decision that documents, over only 2.5 days of trial, documents the evidence in pretty great detail and credits some of the points or all of the points that Mr. Edwards made. And I think the central point with respect to the surveillance evidence is this was done after the discovery deadline, and it was allegedly substantive evidence. The rules are strict. They say that you cannot do more discovery and then hide it from the other side after the discovery deadline. So to the extent that this was, as Mr. Edwards has said, critical to his case, it was not ever, the surveillance evidence was not listed in his exhibit list. So how can he use an exhibit that was never disclosed on his witness list? He disclosed Mr. Dyke after, on the eve of trial, but he didn't list him as a PI, and he did not follow Rule 26, which absolutely requires, I had asked the name of any persons that have conducted surveillance, and it was not supplemented. And there's another section of Rule 26E, number 2, which talks about amending discovery responses when they are going to be misleading. So I think that was violated too. In terms of the Dr. Sweet deposition, really that he was a treating provider. He listed and described in great detail over 160 pages, 3 visits. Those records from those visits, by agreement of the parties, was in evidence before the court. And so all of that information was already before the court. There was no harm at all from use of that deposition. And then finally, the reason we had to do Dr. Sweet by his transcript, he was scheduled to testify when Guy Rohrdorf, the defense expert, was going to testify the afternoon of day 2. It was Dr. Rohrdorf who was unavailable on day 3. And maybe foolishly, I agreed to Jeff's request to take his expert in lieu of Dr. Sweet. And then later, after the trial is over, I find that I'm—
Can I ask you just to clarify something you said in your opening?
Yes.
I think you said that you can't do discovery after the discovery deadline and then use it at trial. I don't know if you misspoke or that's what you intended to say.
Well, I think—
And let me just ask you this. Can you continue to investigate a case after the discovery deadline has run? Is there a rule that prevents that?
there's limited circumstances where you can't use it as substantive evidence if it hasn't been exchanged in discovery.
I get that, but
Right.
I think you said you can't do discovery after the discovery deadline.
Oh,
and then
yeah,
use it to- Okay, so,
I didn't misspeak. I meant exchanging discovery and
Okay.
trying to come up with exhibits.
And let me follow up on something else you said
Sure.
in your protected time. I thought you said that the video wasn't ever listed as an exhibit. I thought it was listed in March 25.
No, I don't think it was listed because there were 12 items in the defense exhibit list and the surveillance video was not there. I could be wrong, but I'm pretty sure I just checked the 12 exhibits that were listed.
So you're saying the video, unlike Mr. Dyke, who was listed as an exhibit, I think it was March 14th, 25 is
Right.
in the exhibit list. You're saying the video, however, was not listed as an exhibit.
From my review of the evidence, I could be wrong, but I believe that it was not listed because I would have kicked and screamed.
We'll check.
Yeah, we will.
One more follow-up to your opening. You allowed his witness, defendant's witness, to go out of order, basically, in the middle of your case. At that time, did you know what the time constraints were?
I did, and we all did, and it was fairly clear to me that because we didn't have enough time, that was going to require Dr. Sweet to appear by his transcript. He was available to be called on day 3 in the morning. He was willing to do that. The court said, I don't have enough time, and Jeff said, I really need to cross-examine the plaintiff, which hadn't even happened yet. And he also elected, instead of trying to use that time to cross-examine Dr. Sweet, if he was so essential, he instead elected to call the driver of the dump truck to say it wasn't much of an impact.
Just so I'm clear, Dr. Sweet was originally scheduled on Tuesday, day 2, correct?
I'm sorry, what was that?
Dr. Sweet was originally scheduled for Tuesday?
Yes, he was available.
But you're also saying he was available Wednesday morning?
He was. Amazingly, he had a lawyer that was on standby. He was going to testify by Zoom, and that's why he was available for both days. He was going to make himself available.
So just so I'm clear, was it the court that made the determination there wasn't time to hear from Dr. Sweet, or?
My understanding from the court's ruling was there wasn't enough time to call him, and so she said, she actually said, I don't know, how you're going to do this, but I moved to, because of the limited time I moved for Dr. Sweet's transcript to be admitted, and under Rule 32A3E, there's broad discretion in the interests of justice, and I think because of the substitution of the doctors, this is a clear example that should be well within the exception.
Well, you referred in the interest of justice. As a trial lawyer, you understand the devastating effect of an opponent's deposition going in when you hope to cross-examine that actual person. You probably read the deposition and found lots of points that you could address on cross-examination. All of a sudden, you're deprived of that, and the deposition goes in as basically uncontested, unchallenged. That's a devastating result, isn't it?
The court did allow us, Your Honor, the opportunity to clean it up, and I've actually put that in our brief. And Mr. Edwards said it's fine. He didn't use that opportunity to.
And I'm assuming that if it was a discovery deposition, we all agree that's a term of art rather than one recognized in the. I'm assuming it was Mr. Edwards who did the vast majority, if not all, the questioning.
Yes, and he asked the same questions a lot of times, and he essentially tried to get Dr. Sweet to agree with Dr. Rohrdorf. Dr. Rohrdorf had been deposed 6 months earlier, and he didn't, and nothing would have changed.
Counsel, how are, just sort of piggybacking on Justice Mead's question, it is a harsh result to say, you have no opportunity to cross-examine this witness live at trial. Certainly, we give trial courts fairly broad discretion to manage their dockets. Time is always difficult, but we do have Rule 32. How are we supposed to sort of balance the strong interest in letting attorneys present their witnesses live at trial with the timeliness concerns? Because it does strike me that this is a fairly harsh result.
Well, I think in this case, if Dr. Sweet was so essential, he could have been subpoenaed by Mr. Edwards. He was not friendly to Jeff Edwards, as the transcript shows. And so, but if he was essential to Jeff's.
That's really a different issue. I mean, the point here is that it was going in. The question is whether he had the right to have a live cross-examination as opposed to the examination for, finding out the information that he would have done.
But this court asked Mr. Edwards, and it's not in his brief, and he wasn't able to respond. There's no harm that he could point to from that he was hoping against hope that somehow he would now agree with Dr. Rohrdorf, even though he said no to all of those questions.
Let me ask the question I'm going to also address to Mr. Edwards. Obviously, the time is running out. It's crunching down there. Did anyone ask the court to say, I'm sorry, we've overshot this. Is there any possibility you can squeeze out an hour and a half sometime in the next month that we can, it was a bench trial, right?
It was a bench trial,
Did
and
anybody make a request to have an opportunity at a later date?
no, it's clear from the record, and I think what I put in, that both sides wanted to get it over with. There was no request for continuance by either side.
All right.
Was there an objection to the deposition coming in?
There was by Mr. Edwards, yes. He
What
did.
was your recollection of that objection?
So my recollection was that the court did say to us, you can try to clean it up, or, I mean, he would have had the opportunity, because of, there were 2 hours or 3 hours in the morning, to call, Dr. Sweet, and he was available. And I could have done that, but he elected, is the way I interpret what happened, to call the the driver of the truck, and to finish the cross of the plaintiff, which obviously was important for him.
So again, I'm not sure I heard the specific objection, though, that he raised at that point. Just other than an objection, was there any clarification of what the objection was?
No, there was, he did object, and it's on the record, but the court said you can work and clean up the transcript, which happens a lot. And incidentally, in personal injury cases, it's not universal, but it's very common for doctors who are very busy, especially neurologists, to appear by deposition. It's unusual to call them live, and especially in this case, I did present our primary expert live. Jeff did as well. This was a treater. So this is a very tangential person. And if you read the decision, there's another neurologist from Tufts. He is a very small piece of the medical puzzle. And I think he answered all the questions saying what was in his records, which is, I found post-concussion syndrome based on the following symptoms. You sure about that, doc? Yes. It wasn't much of an impact. I know, but I still think she suffered it. It's essentially, that was not going to change, and there's been no showing that there would have been any change in what he was going to say in cross.
Looking at your motion to eliminate that's in the record, it doesn't appear that it makes reference to provision of any videos or photographs. Was that part of your discovery request?
It was, and in fact, it's also, if you look in the part of Justice Archer's decision, which is on the record, which is, I think, in 28 through 30 of the transcript, she is very clear, and she goes over, we did ask for photographic evidence of the plaintiff in RPD number 24. And also, as I said earlier, I don't think this was even listed as an exhibit. So to complain that it wasn't admitted when it wasn't even listed is bold. All I have, if that's all.
Thank you. And Attorney Edwards, I believe you reserved 2 minutes for rebuttal.
Thank you.
What's the precise objection to the report coming in?
Video
I'm sorry,
deposition.
deposition.
I did object to that.
What was the precise objection, other than I object?
Because Dr. Sweet should testify live and in person, which is the rule, in my opinion, under Rule 32, subject to exceptions. Dr. Sweet, we knew for 3 days that he was available and would testify. He's going to be testifying by Zoom, so it's not like he had to get into a car and drive from Augusta to Lewiston. He was available by Zoom to testify. And again, the reason he didn't testify had nothing to do with.
He didn't fall under any of the exceptions, is what you're saying?
No, he didn't fall. He was available, and the point, the reason why he didn't testify
was there an
is that.
opportunity for you to actually have him testify? Was there an opportunity for him to testify on Wednesday, the third day, the morning of the third day?
I mean, we ran out of time, and the trial court was very iron-handed about it and wouldn't. We were done at noon on April 16th, and there was no negotiating it, okay? I mean, the decision to shut down the trial was made by the trial court.
So is the argument really that it was inappropriate of the court to shut down the trial? which is a little bit
I
different.
think that was an abuse of discretion, because I would just make this point, that Attorney Clifford and I worked cooperatively in terms of presenting the testimony of the witnesses. I don't think there was any jockeying, any motions that had to be filed. And we just ran out of time. And in trials, you run out of time sometimes.
Did you implore the court saying, can you just please find an hour and a half some
Yeah,
point?
that was it. I mean, we were told unconditionally that we were all done at noon on the 16th of April.
To the extent that there apparently was a discovery request for video or photographs of his client, did you have an obligation then to
The
disclose
video
that?
photos were listed as an exhibit by defendants.
Well, my question was, do you have an obligation to advise them of those materials as a result of having to supplement your discovery?
I mean, again, obviously, to the extent that they were trial exhibits, they would have been provided to plaintiff prior to trial. But in terms of discovery, there was never a request for surveillance evidence by plaintiff. Again, you can look at pages 38 and 39 of the appendix, and there is no discovery request directed at surveillance other than the question about investigators. And there was no obligation to supplement under Rule 26E.
May I follow up on? Well, that's the motion for eliminate. I was talking about discovery requests, and there's a reference, as counsel was pointing out, I believe it's the request for production number 6, which sought photographs, videotapes, and recordings relating to.
I mean, again, Your Honor, looking at page 39 of the appendix, our plaintiff's request for documents number 6 is the accident scene. That's, you know, the crashed up cars, if you will. You know, what happened at the scene. That's not surveillance. Again, you look at everything on pages 38 and 39 of the appendix, everything's a question of interpretation, but there's really no express request for surveillance, and obviously the rule requires that they describe what they're looking for with reasonable particularity per Rule 34 of the Federal Maine Rules of Civil Procedure. Thank you, and I apologize for going over.
Thank you. All right, thank you, counsel. As is our usual practice, we will be taking the matter under advisement and issue a written decision in due course. And with that, we are in recess for the day.
All rise.